legal considerations in construction contracts. We got
Mhm.
kind of two subcategories here, right? So we have key clauses to protect you, which is kind of what
Sure.
you're talking about. And then what's the role of mediation and arbitration and resolving disputes? So what are the key clauses to protect a contract? And I guess you could talk for both subcontractors and
Yeah.
GCs.
So the big thing to know about contracts, there's two kinds of contracts. One, there's the contracts you can't negotiate, and there are the contracts that you can negotiate. If Department of Public Works is saying, here's our contract, follow our contract, you're not going to start marking that up. You can try. They're going to say, oh, look at that. The next lowest bidder is suddenly became available. So in those situations, we like to counsel our clients on, these are the details you need to know. You can't change it, but let's navigate. So some of the things that we've hit on before: notice, change orders, delays, disputes, indemnification, manpower, scheduling, right? So we've seen some contracts where the GC has the right to direct the sub to provide more labor without a change order. Hey, you have 5 guys on site, we need 10, this is your cost. So where are these hidden landmines, and how do we take them out of the shadows so the subcontractor or the GC can say, we need to plan around this? Another big thing we see, private and public, are liquidated damages. If you don't hit your scheduled milestones, we can charge you $1,000 a day. Well, no, I don't want to be charged $1,000 a day.
Right.
There was a delay here. How do I protect my delay rights? So on the public side, in some private contracts, you're not going to be able to touch a thing. You just have to know where the devils are, where the landmines are, and an attorney and you're working with your project folks can help you identify that. Because if you go in early knowing what the problems are, you can solve the problems before they get bigger. On most private contracts, you can negotiate with the GC, you can negotiate with the owner, you can negotiate with the sub. At the very least, I try to get them better provisions on notice. You have to tell us if your project will be delayed within 72 hours. 72 hours happened on Friday afternoon. It's Monday morning. I blew my window. How am I supposed to know that this is going to cost me $10 million? No, let's get you some more time so you can talk it out. To combat this, I've seen some subs and GCs send notices every Friday. Our project was delayed because we missed the elevator because the bricklayer got in there before me, and I don't know what the impact is, but we anticipate it being substantial. Lunch was cold and our workers weren't happy. This could be a significant delay to the project. We don't know the impact yet, but be on notice. Most contractors aren't going to do that. So it's giving them more time to flesh out problems. Working change order language that's more favorable. Well, if I can't find an agreement, how do I get paid? Do I get paid under some determined by the architect? Do I get it on time and material? What's better for my trade? How can I make this situation better for me? Hidden damages clauses. You'll get something that's called consequential damages. Okay, there was a breach in the contract. Because I couldn't do my work because of the preceding contractor, I had an impact. A lot of times you get more time. Sometimes they're going to say, whoa, because you couldn't do your work, we lost profit on another job. Are you really going to be on the hook for someone else's other job? We're mindful of those provisions, and we try to work them in or out depending on where we are.
I just want to expand on the delays.
Mm-hmm.
That was a big thing when I was running my own jobs out in the field, right? And that was one of the main things that I had drilled into my head when I just started to run my own work. Is
Mm-hmm.
I hated doing schedules. I always try to outsource that to whomever else, but I needed to be a part of the scheduling process,
Mm-hmm.
right? And I always made sure that in my regular schedules, my monthly schedules that we had to submit part of our contract, and also my look ahead schedules that I also sent to the inspectors and the owner's reps. I I made sure they understood that a change order was delaying the project or something, like, for example, them not getting a submittal back to me in a
Yep.
certain amount of time, because the spec allocates a certain amount of time that the inspector has to get a
Mm-hmm.
submittal back. Sometimes it goes above and beyond that.
Sure.
So I would always make sure that my schedules reflected that delay, because guess what happens? Like how you said, liquidated damages. And when you're in a city like New York City, liquidated damages could be 10, 15, 20, thirty
Mm-hmm.
thousand dollars a day. I remember when I was out in lane closures, and this is kind of a little bit separate, but when I was out in lane closures, for every 15 minutes over a lane closure hour that I had to pick up a lane closure, it was like $1,500 for every 15 minutes. Sometimes
Sure.
$5,000. On one job, it was $5,000. So it's really important to document delays, whether it be a submittal delay or a
Mm-hmm.
submittal revision delay or just a delay caused by a change order. So
Yeah. You gotta. It's a must.
yeah. So the final subtopic of this last topic is the role of mediation and arbitration in resolving disputes. You want to expand on that?
So dispute provisions happen, and disputes happen when we can't agree. We're owed money. They don't think we're going to get the money. There's a delay. They say it's not compensable. We think it's compensable. They want liquidated damages. We don't think we have to pay. Now what? We've tried to work it out directly. We tried to handle it as business folks, but it just didn't work. And now we have to go legal to a formal dispute resolution. Now we're seeing two main types of dispute resolution. We think, okay, we're going to run into the courthouse. We're going to tell a judge what went wrong, and we're going to get paid. That's one way. The other way is we're starting to see a lot more of it is arbitration. So what's arbitration? Arbitration is a private dispute mechanism. Basically, instead of going to court, guy or gal in a black robe telling us you're right, you're wrong, a jury, we're going before somebody who we hope is experienced in construction. We hope that we know we're going before someone who's been an attorney on construction projects, that they know the ups, they know the downs, they know what could happen. That's truly an expert in construction. And they will hear the dispute. The parties will exchange evidence. They will have witnesses come up. You'll have experts. And from there, this attorney, sometimes it's not an attorney, this person will determine the resolution. The pros of arbitration are it can be quicker. A court process can be 3 to 5 years. And the judge who's handling your case may be dealing with a dog bite, may be dealing with a foreclosure, and then he's dealing or she is dealing with construction project gone wrong. They may not be the most equipped to handle our specific construction issues. The other benefit is the law is more loosely applied. What that means is you go into court, if you didn't comply with every single line of the contract, there's a good chance as a sub, your case may be thrown out. If you didn't submit your change order when the moon was at its highest peak in pigeon blood, and it was written on a scroll from the 16th century, a judge in New York will throw you out. In arbitration, you may have a better shot at getting your money. Usually, before arbitration, they make the contracts now are making the parties go to mediation. Mediation is much more informal. Similarly, you're going to go to hopefully a construction professional who knows the industry. They'll sit down with both sides, the sub, the GC or the owner, and say, what happened here? Well, we had these delays, we had these impacts, this change order hasn't been paid. And he makes a recommendation. He could try to discuss the pros and cons of each side's case while also saying, hey, this goes to court or this goes to arbitration, you may have a problem. So it's a way to try to resolve things before people spend a ton of money and a ton of time in arbitration or in court. And it's really a nice opportunity for everyone to take a deep breath and say, okay, I have my professionals here. They've been telling me something for the last 6 months to a year. The other side's been saying something else. Now we have somebody who we can listen to and they could say, okay, the other side is right here. We're right here. Let's try to come to something in the middle so we don't have to spend lawyers. We can spend that money on our professionals who can help our business grow in the future.
That's all. This video has been all gold, man. I hope growing contractors are going to watch this video multiple times because there's so much information here. And I mean, I've said this many times on all my social media accounts as well. And if there's one business that's probably the most riskiest business in the world, it's got to be construction in the top three, right? I mean, there's so many there's so many moving parts in this business, you know, and there's so much to learn, and there's so many resources, like people like us, for example, where, you know, you can either learn the hard way and be reactive all the time, or learn the easier way by picking up the phone and asking for help and be proactive, you know. So unless you got something else, Seth, that you want to add anything else before we close up this video?
As I tell all my contractors, make sure you get your change order signed.
Every day. Every day.
day.
Well, your T&M sheets should be signed
Yes.
every day. Your
Yes.
T&M sheets, your time and your material sheets, if you don't know what that means. I was always taught you got to have them signed every day, and then as soon as you're done with that change order, you submit it right away.
Right away.
So,
Early and often. Don't let things linger. Talk to your professionals. We're here to help you, because the earlier you get us involved, the more we can do.
you're hearing that from the mouth of a lawyer. 14 years in the business, he knows what he's talking about. So, Seth, if people need legal advice from you in this area, you know, what states do you work with? One, and then two, how can people find you and contact you?
So I do a lot of work in New York, New Jersey, some work in Connecticut, public and private, material suppliers, contractors, GCs, and owners. You know, I do it all, so I've seen a lot of it. Where you can find me, I'm on LinkedIn. Wherever Jerry's posting, you can find me liking and commenting. Don't Google me. Don't Google me, because my funny alter ego Seth Meyers will pop up. You can always get me at Kaufman Dolowich. We're a great firm that helps a lot of the construction industry with construction issues, labor issues, contract issues, and workplace injury issues. So we're here for you. We're a friend of the trades. We're a friend of the GCs. We're a friend for everybody.
Awesome. Thanks, man. And I'm Jerry Aliberti, owner of Pro-Accel. If you're watching this video on YouTube, I encourage you to subscribe, like, and comment. Comment any questions that you may have for Seth, and I'll forward it to him. Go to my profile, go to my website. Under free resources, you can also find this video with a blog. And I'm on social media. I'm on Instagram. I'm on LinkedIn. All my accounts are under my YouTube profile account. Seth, thanks again for coming on board, man. Until the next time.
Thank you for having me. And just remember, this could be attorney advertising. Prior outcomes do not guarantee future results.
Wow, look at that. Awesome note to end on. Thanks, man.
Thanks for having me.